on the right-hand side of the timeline. And it did that after it hired new counsel, GST. It simply defies all credibility that Freshfields, a sophisticated and experienced law firm in international arbitration, was not aware of these series of challenges that were published and discussed publicly. In addition, the parties in these other challenges stated on the record that their own challenges were prompted by these very same media reports about those other challenges. In other words, these were piggyback challenges. In the ICSID case, Spain stated that the facts only came to light when public reports of such relationship emerged in July 2017 as a consequence of a challenge filed in an unrelated arbitration involving Pakistan, the TCC case. These public reports were made on July 11th and July 12th, 2017, and Spain filed for annulment on July 21st, 2017. Likewise, in the TCC case, Pakistan filed a second disqualification proposal on November 25th, 2017, shortly after public reporting about his disclosures in the Solas versus Spain case on September 19th and October 24th, 2017. Counsel to Guatemala, just like counsel to Spain and Pakistan, were well aware of these challenges, yet Guatemala did not challenge Dr. Alexandrov in this case. And we would also note that Guatemala, throughout the original arbitration, the resubmission proceeding, and this annulment proceeding, has relied upon press articles and other types of press release statements and put them into the record. So it does follow the press on a regular basis, including press like GAR and other types of arbitration-related reporting. Based on publicly available reports and filings, Guatemala also knew or should have known that Navigant had been represented by Sidley Austin. In short, Guatemala has no excuse for not raising these facts and circumstances years ago. All of the information Guatemala relies upon now for its annulment application has been in the public domain for years. Having failed to raise any challenge to Dr. Alexandrov in the resubmission arbitration, Guatemala accordingly has waived any right to seek annulment. And I will now turn the floor back over to my colleague, Ms. Menaker, who will address Dr. Alexandrov's independence and impartiality.
An issue that hasn't quite been articulated and which I raised earlier and no doubt will be the subject of a reply by Guatemala is the duty of counsel to draw to their client's attention opportunities for exercise of rights. And I would be helped by some submissions in relation to the duty of Freshfields to draw to their client's attention rights that they may have with respect to the issue that's been the subject of the submissions you've just made. In your submissions, it's not entirely clear what you say about that. You've said Freshfields should have known, Guatemala should have known. Now, just speaking from experience as counsel, despite the well-informed character of in-house counsel within governments, they are often supplemented in their information by the counsel they engage as outside counsel. And I'd be interested in both parties' submissions on the extent to which it is fair or otherwise to treat the party as the party with its counsel or not.
Mr. Sorry, Mr. Torterola?
Break. I mean, just for the consideration of the tribunal.
Would this be a good moment for you to do the short break?
Sure.
Yes, I would just before we move on to the next issue, could we perhaps get a table with all the cases which have addressed the issue of whether a prompt or an issue had been raised promptly? Can we just see what each case said was promptly? We've seen here 18 months, not more than 6 months. I have no idea. Here we've seen several years. So what have they said about prompt? Because that's
Madam President, do you need that chart necessarily by tomorrow?
no.
Yes, because we are working in 2 time zones here. I mean, we have our team in Washington, we are here in Europe. Maybe we can have some assessment by tomorrow, but to really have the chart put together, I will request a few days after the hearing to do that.
I mean, I'd like to see it in writing at some point. So,
Okay.
and there's lots of examples given in the memorial. So I think it won't be too difficult to just pick those and put them in a chart instead of like in a table.
Could I suggest that the parties do that by Friday, the day that we have questioning, because again, we're only looking at the cases that are on the record. So we have that, and then that way it could be of use to the committee during Friday rather than, if it has any questions on those.
Then my next question would be, is the tribunal committee referring only to those cases that are in the record about this topic? Because this topic is much larger than the cases that are in the record, which has not been necessarily the main issue debated here.
That it has not been the main issue,
The
whether
main
it was
issue
promptly
debated-
raised.
Yes, I mean, what is prompt and what is not prompt.
I think it's been a big issue raised, and we have quite a lot of authorities on the record on that.
The number of authorities. Let's keep it on what's in the record for now. We may revisit this later, but
Okay.
for now, just what's in the record. There's quite a number of decisions. So if you can just put it in a neat way, so it's easier to see. Excellent. So now we break. Let's say for 10 minutes, 15, 5. Let's make it 5 because we're all 10. Okay.
Whatever you want.
Yes,
That's
a
fine.
6:15 until 6:15. Okay.
Yes.